Okay, it looks like it's slowing down a little bit, so I will go ahead and get us started here a little bit. Thanks everyone for coming tonight, and anyone who's watching the recording, thanks so much for tuning in. We really appreciate it. My name's Laura Shannon. I'm one of the presidents of the National Plaintiffs Law Association. We are about 1 or 2 weeks away from our job fair, which is a event that I have been dreaming of for more than a year now. So I'm really, really excited to have the opportunity to build a more robust community of law students interested in plaintiffs' law. And I think one of the most important parts of that is sort of teaching law students what plaintiffs' lawyers do. And so that is the thought behind this panel, is particularly when you talk to plaintiffs' lawyers, I think the people who are the face of the plaintiff's bar are partners. They're sort of like the big trial attorneys. And so it makes it kind of hard to know what the associate experience is like. Whereas for a lot of us, the associates at big law firms are on our campuses pretty frequently. So we are just going to go and hear from a few associates at some big plaintiffs firms. Yusuf Albazian is one of our founding members, and he's going to be leading the panel tonight. Really appreciate everything that he has done. Truly such an incredibly hard worker, and I will pass it off.
Hi, everyone. Thank you for being here. And I'll start with introducing our panelists. So our first panelist is Molly Frandsen. She's a 2017 UC Berkeley Law graduate and an associate at Outten Golden, where she's a member of the firm's class action practice group, specializing in employment class actions. And prior to joining the firm in 2018, she clerked for the Honorable Chief Justice Mark Rechtenwald of the Hawaii State Supreme Court. And our second panelist is someone who I actually know personally, John Davidi. He's a UC Law SF 2018 graduate, and he's an associate at Panish, Shea, Boyle, Ravipudi, where he represents individuals in complex personal injury, wrongful death, and product defect cases, and has obtained over $100 million in verdicts and settlements, and been named a Super Lawyers Rising Star, and named to the 2023 Best Lawyers Wants to Watch list. And the last time I heard him speak, he's who inspired me to join our trial team at school, because he was an AAJ national champion. Our third panelist is Emily Beale. She's a 2020 Seattle University Law graduate and is an associate at Gibbs Law Group, where she represents individuals and consumers harmed by financial fraud and corporate misconduct in complex class actions. And prior to joining Gibbs, she clerked for 2 years for the Honorable Benjamin H. Settle in the Western District of Washington. And this is a fun fact, which I know a lot of law students here will appreciate. She finished top of her class and had 8 Cali Awards in law school. Our last panelist is Fred Messner. He's a 2022 Harvard Law graduate and an associate at Keller Postman, and the director of Camp Lejeune operations. And while at Harvard, Fred served on the founding board and was co-president of their PLA. And prior to law school, he worked as a technology investor at Severica Capital Management, an SF-based private equity firm, and as a management consultant at McKinsey. And I'm really excited you guys are all here to speak to us, and thank you for taking the time. And let's get right into it. Our first question is, we want to hear a little bit more about you. So if you could tell us a little bit about yourself and your path to the plaintiff side, and kind of describe what your practice area is, because I know there's so many different areas within the plaintiff side. So just tell us a little bit about what your area is. And maybe if we could start with Molly and then go down the same order as introductions.
Sure, thank you. So my name is Molly. I'm an associate at Outten Golden. It's a firm of plaintiffs' attorneys dedicated to representing employees. There are about 65 attorneys across 3 offices: San Francisco, New York, and DC. I'm based out of the San Francisco office, and the firm is sort of separated into 2 groups: a class action group and a side that represents individual employees, and I work on the class action team. So my path to the plaintiff side, so going back to college, I was interested in workers' rights. I interned with an SEIU local during college, and I was a labor studies minor. And I just sort of fortuitously ended up as a paralegal at a labor and employment law firm after college. I didn't have attorneys in my family. I didn't know about plaintiff side work. So that informed my decision to go to law school. For those of you in the Bay Area that are interested in employment law, you might be familiar with the Legal Aid at Work's Workers' Rights Clinic. I was able to work there as a paralegal. I was connected through a coworker, and they needed Spanish speakers. So I was introduced to Bay Area plaintiff side attorneys there. And so from there, I decided I wanted to go to law school and explore plaintiff side employment law paths. And my experiences during law school really confirmed my goal to become a plaintiff side employment attorney. I really enjoyed civil procedure. I ended up serving as a research assistant for my civil procedure professor throughout law school. And I spent my 2L summer at Outten. And so from what I could see there, the firm's work and its mission and the people who worked there, I wanted to return. So after I spent the year clerking in Hawaii, I returned to Outten Golden in 2018. For what my practice is like now, I'm assigned to a variety of cases, the majority of which are wage and hour. What that looks like is cases that allege that across the company, employers either misclassify their workers as independent contractors and don't pay them as employees, or misclassify them as exempt from overtime, or just force them to work off the clock, require them to come in at a certain time but not clock in, or to falsify their time records. And the practice group also does Title VII discrimination cases, including pay equity and hiring discrimination, including based on criminal records or credit history. And so, my cases are at all different stages, from pre-litigation settlement discussions to heavy discovery, to motion practice. So I'm happy to answer more follow-up questions about, my specific day-to-day or what my practice looks like.
Okay, thank you. Well, definitely want to know more about that following up, but maybe if John, you could tell us a little bit about practice area.
Hey everyone, my name is John Davidi. I work at Panish, Shea, Boyle, Ravipudi down in Los Angeles. I do plaintiff side personal injury, mostly single plaintiff PI, car accidents, product liability, premises liability, construction cases, any whole lot of tree falls someone and hurts them. We're handling a case like that right now up in Burlingame. Anything that you can imagine happening in the world has happened or will happen. And usually it's because someone was negligent, and that's what we're here to prosecute at my firm. So we handle those types of cases, mostly more complex ones, mostly more catastrophic ones. I could talk a little bit later about kind of the ecosystem of plaintiff side personal injury law in LA and California and across the country. But that's a little bit of an intro to what I do. Every day I'm doing something different: discovery, depositions, trials, arbitrations, outlines, mediation briefs, mediations, whatever it is, the whole lot, the whole gamut. I'll tell you what I don't do a lot of is doc review.
And Emily had a story similar to mine where she worked as a paralegal and found her way into the plaintiff side that way. How did you find your way into the plaintiff side?
Well, if you asked me when I started law school what kind of a lawyer I wanted to be, I would have said I have no idea, but I don't want to be a personal injury lawyer. That was the only idea that I had, because where I'm from, every personal injury lawyer is a billboard, and I didn't want to be another guy on a billboard doing that kind of work. I wanted to do real legal work, which in my mind meant big law or some mid-sized firm or some BS that I thought was important or big time back then. And then as I was on the trial team in law school, I started to like it. I really like trial advocacy. And if you're on a trial team now, or if you're going to be joining one this year, you'll see that basically all of the problems are either criminal or personal injury or employment, because those are the cases that go to trial. And I knew I didn't want to be a criminal lawyer because I don't want to deal with people's freedom. I knew I didn't want to be an insurance defense lawyer because why would I do that? And I clerked at a plaintiff's firm in San Francisco called Walkup, and was interesting to me. It was intriguing, and I kind of saw a path to being a personal injury trial lawyer where I get to help people. I don't have to bill my hours. I get to do something that I like. And there is, to be honest with you, a lot of work-life flexibility in this field of law, which I really like as well. So that was kind of what guided me there. I started in big law at a firm called Venable, and that lasted 6 months. And then I quit and went to my first PI firm, taking a 50% pay cut. I had barely enough in my savings to make it through the first year, but we did. And slowly but surely, I built my book of business a little bit, and now I love my job and love what I do and love helping people.
That's awesome. Thank you. And Emily, how about you? What was your path to plaintiff side like in your practice area?
Hi, everyone. Thanks, Yusuf. My name's Emily, and like Yusuf said, I'm an associate at Gibbs Law Group. We're a firm about 30 or so attorneys, primarily based in the Bay Area, but with some practitioners across the country. I myself am based in New York City, and we have folks all across the country. So I primarily focus on financial fraud cases. Usually what that encompasses is holding third-party financial institutions accountable for some type of fraud or negligence that occurred, because usually the fraudsters themselves are bankrupt. So that has been a really interesting practice area that I didn't see myself necessarily going in, but you know, as an associate, you sort of sometimes have to go to where the cases, where the needs are in the cases, and that's how I sort of found myself in this niche. It's been a really great year so far. So as you have said, I previously clerked for 2 years, so I was exposed to all different types of litigation during my federal clerkship. But I always knew that I wanted to be a plaintiff's attorney, not because I necessarily knew what that was going into law school, because like Molly, I had an excellent civil procedure professor who I also was a research assistant for, and she really pulled back the curtain and said, there's something beyond big law. My first summer, I sort of was looking at either doing direct services work, helping people, because that's why I went to law school for. But I also applied to the Steiger Fellowship with the ABA, which places students at various AG offices across the country, working in their consumer protection and antitrust divisions. I kind of knew what antitrust was. I don't have any lawyers in my family, and consumer protection sounded like we're protecting consumers. So I was all on board on that. So my first summer, I worked at the Washington State AG's office primarily in their consumer protection division. And it was just some really great people, and mostly folks who had burnt out from big law, who had decided to take the pay cut and go, prosecute the companies that they were previously working with. And they really encouraged me, they were like, you're bright, you should go through OCI, because that's the only path that they saw. They saw the only path was go, cut your teeth in big law and then come work for us in about 5 or 6 years. So nobody really encouraged that until my civil procedure professor linked me up with some plaintiff-sided firms in Seattle. So my 2L summer, I worked at Terrell Marshall, which is a smaller to mid-sized firm, also doing class actions in Seattle. And sort of post-clerkship found my way at Gibbs, and I'm coming up on the 1-year mark now. So happy to talk about what it's like as a first-year associate, because I know that sometimes is a scary thought, but it's been really excellent. Some doc review, I have to say, but hey, so it goes.
Thank you. And I love that your professor helped you get into the plaintiff side. Eric Gibbs has been connecting us with so many professors, and they really know where their students' passions lie. So it's definitely a great way into the plaintiff side. How about you, Fred?
Sure. Hi, everyone. I'm actually going to start with my path into plaintiff's law before telling you about KP, because I think it's kind of helpful to frame up what KP is and how it works. So I was a management consultant, and then I had a brief career in finance as an investor at a private equity firm. And I woke up at some point in 2017 or 18, I guess, and I thought, all I do every day is I make rich people a little bit richer. But what if I could wake up every day and make them poorer? And I was kind of thinking about different ways I could do that. And I actually found plaintiff's law as a way that I could do work that I felt put me on the right side of things, cosmically, I guess. But also, I'll just be completely honest, I knew I didn't want to take a vow of poverty. And plaintiff's law seemed like a good way to balance that. So I actually knew going into law school that this is what I wanted to do. So KP is in some sense sort of the confluence of all these things I've ever done in my life, and it's sort of perfect in that sense for me. And Keller Postman is a bit agnostic. We don't do just wage. We don't do wage and hour, personal injury, or torts, or anything like that specifically. What we focus on is we exclusively do cases where there are a large number of similarly situated plaintiffs, but there is some reason, it could be contractual, it could be legal, or some other kind of legal, where you can't do it as a class action. So you might have, if anybody has heard of us, it would probably be because of the mass arbitration project that we pioneered, where we bring tens of thousands or even more than 100,000 individual arbitrations all at once. We also do a lot of mass torts, where you have thousands of individual plaintiffs and you can't aggregate it into a class, or you can aggregate it, but you can't treat it as a class. And then we are also doing Camp Lejeune right now, which kind of is a mass tort, but adds an interesting administrative component as well. And what ties all of those things together is to bring those cases, we don't just need to be good lawyers, but we also need to be good at ops, and we need to be kind of tech savvy. And we also need to be good at marketing, and we need to be good at raising capital, because if you're going to actually have 50,000 people retain you, there's a lot that goes into that outside of sort of the typical core competencies of lawyers. And that's why, for me at least, bringing some of those skills from earlier in my career, it made a lot of sense for me to be doing this kind of work. I right now am titled the director of Camp Lejeune operations, which doesn't really mean much, but the way that evolved was I graduated in 2022. I was originally planning to just come to KP for the summer, study for the bar, and then do a clerkship. But I liked it so much that I actually reneged on the clerkship like 3 weeks in advance, which may or may not be frowned upon, but is definitely possible. And part of the sort of thinking there was Camp Lejeune was just starting up. They told me that I could keep taking as much as I could handle, and they just sort of never stopped me. And now I sort of sit at the middle of those tech and operations and finance pieces that I talked about, but also as we get deeper into the litigation, which I'm happy to talk about more later, I've also had an opportunity to work on a lot of that stuff as well.
Thank you. That's a very interesting path, like the confluence you're talking about of those different experiences. I guess my second question, one would be more along the lines of why plaintiff's law, because whenever we talk to plaintiff's lawyer, the one thing that comes up is really the passion for the practice area. Plaintiff's lawyers are some of the most passionate advocates that you'll meet. And I'm a little curious about where that passion comes from, and what experiences do you have as an associate that kind of creates that passion that we see across the board? Maybe if we start with Molly again.
Sure, thank you. Yeah, so I mean, I was attracted to plaintiff's law and continue to be happy to be here. For, you know, I like the mission, the goals of the litigation, that plaintiff side work holds employers accountable. You know, employers can serve it, like litigation can serve as deterrence for other employers not to break the law, commit wage theft. It can be really great impact litigation. So for example, I worked on a case, and our firm has done a number of cases that are a bit more novel, cutting edge on criminal history discrimination. So for example, the case I worked on, we alleged that the company's hiring policies that barred applicants with past convictions violated Title VII because the policy had a disparate impact on applicants of color. And the settlement, among other things, provided for the company to work with experts to revise its hiring policies. So what's called injunctive relief can be really great impact litigation. And then, you know, on top of all of that, it provides a remedy. Like really great to go from like doing an intake with a client to a number of years later, getting them a check for the wages that were stolen from them. And I also, beyond that, just really like the work. I like that I like civil procedure. I like research and writing the interesting issues that come up in plaintiff side work. I think it at least in my practice on the class action side, I think it's a good balance. I interact with my named plaintiffs and some with class members, but it's not like direct service. I get that balance working with clients, hearing their stories, but also doing the independent work and then collaborating with my colleagues, strategizing and collaborating on cases.
Thank you. John, how about you?
I had to take a call when you were asking the question. So what was the
Oh,
question?
no problem. No, the question is kind of why plaintiffs law. So basically because, we talk to plaintiffs lawyers across any practice area and they have so much passion about what they do and they just seem to love it so much. So what's something as like the associate's experience that kind of drives that passion? Where does it come from? And why are you so passionate about what you do?
First of all, you're totally right that plaintiffs lawyers like their jobs. And in my experience, the only lawyer friends or lawyers that I know who like their jobs are plaintiffs lawyers. Like it's literally as simple as that. Or like people who start their own firm and run their own business, but like that's a 50-50 hit rate. Some people burn out and then have to go join a firm and their life sucks again. And some people have a lot of success. But this is just the type of work that excites me and is interesting. And the easiest way to put it is when I come to work, I feel like a lawyer. I feel like what I thought a lawyer should be doing and is doing, and I get to do it all the time. I don't do a lot of, I don't know what like the proper term for like bitch work is now, but like I don't like I do real substantive stuff on a daily
Document
basis.
review.
Yeah, I'm talking to opposing counsel. I'm, working with the partners. They're asking for my opinions on things. I'm running my own cases. I'm taking my own depositions. We're coming up with litigation strategy, and there is a result and a goal that's in sight. And at least for single plaintiff PI cases, the length of the case is pretty reasonable. A case is going to get to trial within about 2 years from when you file. Whereas if you're at a big law firm and you're in one of these like super complex, like 8-party business litigation suits, you're going to be like dealing with motions to compel discovery for 2 years. And that's very annoying. Um, in my line of work, when we're talking about single plaintiff personal injury, you're always dealing with an insurance company on the other side. Even if the named plaintiff is a corporation or an individual, you're always dealing with an insurance company. You're dealing, for the most part, with experienced insurance defense lawyers. And the reality is, everyone knows the game. Everyone knows the game. We all know the chess moves for the most part. And so, what does that mean? It means that our jobs are a lot easier than other people's jobs because you're going to, let them do a second medical examination, even though they're only entitled to one under the code, because you know that they're going to win the motion to compel. We're not going to file frivolous stuff. We're not going to waste anyone's time in these types of cases. Everyone kind of knows how they go. Everyone knows kind of what the value of a case might be, what needs to be done before it gets to settlement, what needs to be done before it gets to trial. And that's what makes it a little bit easier. To be honest with you, I'm kind of, I think Molly and I kind of differ. I hate legal research and writing. It is the least favorite part of my job. I would rather, I have an arbitration next week and they just filed some motions in limine. And in my mind, I'm like, I don't want to write oppositions to these. I just want to show up and argue what my opposition is. And I'll win if I do that. Like, that's what I think. So for me, I don't really like writing or like proper briefing and doing the research and finding the case law and issues of new impression. Like, that's not interesting to me. To be honest with you, I know we're talking to law students. Like, the law itself isn't particularly interesting to me. Facts are interesting to me. What happened is interesting to me. Telling a story is interesting to me. Being persuasive. These are the things that I get to do in my job on a daily basis that excite me. And the good thing about the firm that I'm at is they want to highlight your strengths. So we have people at our firm who are amazing writers, and we give them stuff to write and they love it. And that's what they love to do. And I want to be in trial. I want to be arbitrating cases. I want to be taking depositions. So those are the types of opportunities that I get.
That sounds like an amazing experience. Emily, how about you?
Yeah, it's a great question. I think I had always considered law school when I was an undergrad. I was a law societies and justice major, which is like poli-sci meets sociology and really studies the impact that the law has on everyday individual lives, which is very esoteric, but it was really interesting. And so I had sort of come up with this idea in my head, and I think is true now out in practice, is that the law impacts our lives on a daily basis. Whether we're consciously thinking about it or not, we're making decisions, and other folks that around us are making decisions that are legal or illegal, up to code or not. And, I really wanted to, I think I see the law as a way and as a vehicle to help people. If you can really master a certain subject area and really understand the ins and outs of it, you can use it for good. And so I went into law school thinking I'm going to be a public defender. I'm going to get out there. I'm going to go help folks who have been accused of crimes. And I really think there's a pipeline from people who start law school thinking they want to be a public defender and then realize, oh, there's lives at stake. This is pretty serious. Public defenders' offices are pretty notoriously underfunded. I don't know if this is necessarily for me. And I think there's a pipeline into then plaintiffs' work, which is sort of how I found my way into plaintiffs' law, is wanting to help people, loving the law, loving just getting into the nitty gritty and the weird, subparts of all the rules of civil procedure, and really trying to see, not necessarily manipulate, but use the law for the best outcome possible. Yeah, I think just really to help people. I think that's why a lot of people go to law school, and there's a lot of firms out there and a bunch of different practice areas that help.
Can I ask you, so you talk about framing like the law in certain ways to help your client. What are some examples that you've had in your associate's experience where you've been able to do that? Because that's, where a lot of your passion comes from, that's made you love your practice area.
Yeah, I think it's really interesting. The primary case that I've been working on over the past year is doing a financial institution for aiding and abetting a Ponzi scheme, and working directly with clients who were defrauded by a 9-figure Ponzi scheme over the course of 5 years. And really, going up against, I will admit, some tough opposing counsel who, if they decided to litigate this, it's cheaper, most likely, for them to litigate this to the ground than make, the changes within their own institutions. So these type of things don't happen. And I think, just really harnessing the power of just like doing the research, trying to understand, what claims we can bring, how do we help these people who have been defrauded? Because, we can, point to the automatic people who, who were running the scheme, but there's also liability elsewhere.
Thank you. This is starting to really seem kind of like a microcosm of what John was describing, where people have differing interests, and you can really find a place where your interests can shine on the plaintiff side. And so, Fred, how about you? What's a way that like your passion has kind of been founded in your plaintiff side experience as an associate, and kind of what are some concrete examples that you've gotten to exercise that interest or passion?
Yeah, I mean, I really do believe this is the best job in the world, and for a lot of reasons that other people have discussed. I mean, you get to actually hold bad people accountable and get redress in very concrete ways. They have to, I think something that gets abstracted away in law school is that when you win a judgment, it's not something abstract. They owe you money in like 90 days. And if they don't give it to you, you take it from their bank. So it's very sort of concrete in that way. You also get to do a whole bunch of diverse work. You can advance really quickly, all of those really good things that are great. One thing that I would just add that nobody else mentioned that I think is kind of fun is plaintiffs lawyers are also just like kind of trolls, and everybody in this world seems to kind of delight in serving as a counterweight to moneyed and sophisticated interests, right? Like it's fun, I think, to be able to wake up every day and think of clever ways that you're going to make sophisticated bad people pay. And a way I did not forget about your question. A way that I think we've sort of brought that out is in this mass arbitration work that we do. So as many of you probably know, whenever you buy a product, or certainly whenever you take a job, you're signing an arbitration clause in which you commit that you will not sue the seller of the product or your employer in court. You will not participate in a class action, and instead, you will resolve whatever dispute in a confidential individual arbitration that is probably skewed against you in various ways. And companies have spent decades litigating these and getting the Supreme Court to approve ever more aggressive divestments of your rights to access the American justice system. And what they've said time and time again is that, well, if you have a problem, arbitration's cheap, easy, and fun. You can just go there, we'll pay all the fees, and if you have a problem, just bring it. And the reason they've been so generous about that is because they've always thought, if we just pay one of these, even if it's kind of plaintiff friendly, that's still better than us having to face a class action. So we came up with kind of a trolley idea of, what if we found a way to do this at scale, and we brought like 100,000 at once and made them pay all the fees? Maybe that would show them. And that is something that we've run successfully tons of times, including one that was so successful at Amazon that they took the arbitration clause out of the Prime customer agreement. So if you have a passion, I guess I have a passion for trolling, and I get to live it every day.
That's a great way to put it. And maybe this time, this question will go starting with you, Fred, and we'll go the other direction, because I'd really love to hear more about that. Want to know kind of more examples of experiences you guys have had in your associate position on the plaintiff side, and kind of, what made you, or what would have made law student you geek out on the concept of, and as sounds like hearing you talk about those mass arbitration strategies, that might be something like that.
Yeah, I mean, I was a big FAA nerd in law school. It was one of the first things that of the many things that are egregiously unjust about our world, I found the arbitration thing to be particularly frustrating. It sounds a little bit esoteric, but it has been such a brazen attempt, a successful attempt, such a brazen mission to prevent people from suing companies for the sole purpose of making it easier for companies to steal from you. And that really frustrated me. I cared a lot about it in law school, and it was really a fantastic sort of stroke of happenstance, or maybe not, that the firm I ended up working at was one that was working on this precise issue. And so I think a great way to navigate the plaintiff's law world is to find things that really piss you off. And they may be landlords abusing tenants, they may be people cheating vulnerable and unsophisticated investors, they may be insurance companies trying to avoid paying out policies for accidents where they rightly should pay someone. And if you can find something where you get to work every day on sort of righting that specific piece of injustice, it can be a really fulfilling career.
Well, thank you. Emily, what about you? What are some of your experiences that would have made law school you kind of geek out, opportunities you've had?
Yeah. Well, first, I just want to piggyback on what Fred was saying and sort of expand maybe on my prior point, is that I think plaintiff's work is really creative, right? It's just inherently creative. Okay, so we have this issue that's being faced in front of us. We have arbitration clause. SCOTUS is requiring us to enforce it. What do we do about this? And we came together as a bar and we said, all right, mass arb, let's do it. Like, they're paying for the fees. Let's show them to put the money where their mouth is. One of my favorite, this is me geeking out now. So one of my favorite rulings comes from NDCal in I think it was the DoorDash litigation, where DoorDash goes to the court and says, please, 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 can we please have this class action in federal court. This is too unwieldy. There's thousands of these workers claiming and wanting to do arbitration with us. And I forget which judge it was, but in the order it says you've made your bed and now you have to lie in it. And it's really just, I think, exhilarating to be part of such a creative community where we're sort of working together and coming up with solutions. We're not doing the deny, delay, defend. It's inherently creative. So sort of on that front, something like I've really was excited about, you know, in this first year is working on this case that we have against Grubhub, who have been listing sort of small business mom and pop restaurants on their platform without their consent. One of the issues, sort of have to get creative with how do you bring a claim? You know, there are arbitration agreements within, the contract, the terms and conditions that you sign up, they're never really signed up, so these arbitration enforceable. So the creative pitch that we sort of went with was bringing a Lanham Act claim, which is like a copyright trademark violation claim. And so I think just living in that creativity and not, saying this is how we did it in previous cases, or there is no clear way out or way through, so we just have to give up. I think that's been really cool to like actually witness. And, you can talk in law school classrooms all the time about like what you would do, and actually being able to like sit there, voice an idea as an associate and have the partners be like, yeah, that is a good idea. We haven't thought about it that way. Let's think about it and let's pursue it. I think that's been a really awesome and rewarding experience, I think, as a young associate and especially as a female associate.
That does sound rewarding, and I love how you highlight the creativity of it. So I 100% agree with that. Molly, what about you? What are your take on that?
Yeah, so definitely a lot of what being a plaintiff side attorney is fighting over procedure. Like that's what defendants do. They don't want to fight about whether they, paid people, like stole money from people or discriminated against people. They just find new ways to try to, and like Fred said, very brazenly, just like not get sued. So my firm has also done the mass arbitration strategy. And so I've worked on those cases, and that's fun. Another, like an experience that, because, that I would have been excited about when I was in law school to know that I would be doing a few years into the practice, was that I argued an opposition to a motion to dismiss for lack of personal jurisdiction. So personal jurisdiction is another way that companies try to get out of being sued. It used to be that for employment cases, as long as the employer had employees working in one state, you could sue them wherever those employees worked on behalf of the whole group, the whole collective. And only in the past few years have defendants been arguing, and circuit courts have been holding that you can only sue a defendant for nationwide wage violations in the state where it's headquartered. Because if you, like, for example, in our case, we sued in California, the defendant was headquartered in Illinois, and the defendant was arguing there's no personal jurisdiction over the out-of-state non-California employees. So that was something where, involved lots of original research, and I handled the argument. So we ultimately, it was also a motion to transfer, and we lost. The court transferred it, so didn't make a decision on the personal jurisdiction issue. But just those kinds of procedure questions are interesting. And, now that there's more of a circuit split weighing in favor of employers, we talk about strategies like, okay, we'll tell a defendant that we'll sue them in multiple places if they are going to argue, do they want to defend 2 lawsuits in Illinois and California? And then just to sort of like go in give a insight into other experience. Like, I think something that I've done a lot of that I didn't know I would be doing in law school is I do a lot of mediations, and I do a lot of pre-suit cases where if there's a straightforward pay practice, you know, we'll just reach out to an employer and say, you broke the law. Do you want to talk to us, or do you want us to sue you? And I've really enjoyed working on those mediations. You get to go in front of a third party neutral and argue about, you know, the whole case. Like, we would win on certification, we win on liability, you know, our facts, what we have to show you. So what we have so far shows that the facts are going to be really strong, and we'd have big damages. And then you do a negotiation through a third party mediator. And it's like a skilled game, and it's an experience that I enjoy.
I like hearing about that strategy aspect of it. That's really cool. Thank you. John, what about you?
Good question. So I think fundamentally what everyone should understand about plaintiff's work versus defense work is kind of the business model of our different firms. A plaintiff's firm is built for the most part on volume, right? You have to have, if you're a single plaintiff personal injury firm like ours, you have to have a lot of cases that you're taking contingency fee on, and you're not getting paid per hour. As my boss likes to say, we don't get paid per hour, we get paid perhaps. Obviously, we only take good cases, so usually we get paid out on our cases, but you need to have a lot more. So I'll probably have 35 or 40 cases on my docket now versus when I was a big law attorney, I had 7. And so the big law or the defense or the different firm model is having fewer cases, more heavily staffed, so that the main partner can make money off of everyone below them, off of all their billable hours, right? So the partner is making money on the junior associate billing $350 an hour, and the mid-level billing $500 an hour, and he'll bill $1,000 an hour here and there. And that's how he makes all his money. Our incentive and the way that we financially sustain ourselves and have lives is by working much more efficiently, right? So you need to have more cases, you need to be able to churn through them at an effective rate, which means sometimes you just need a warm body to do something, which means that a younger associate gets a lot more opportunities, right? We have 30, 40 cases, and there's depositions going on all the time. There's hearings going on all the time. I may not be able to cover everything. So our first year associate's going to have the opportunity to do a deposition. And the good thing about our cases, like I said earlier, where everyone kind of knows the chess moves, everyone kind of knows what's going on, it's easy for me to teach the first year associate, here's what to expect, here's what they're going to ask, here's what you need to be prepared to rebut with, right? And yes, she's a little nervous. Yes, she's a little scared, but she jumps in the fire and then she gets much more comfortable much more quickly. So we, as plaintiffs attorneys in my line of work, have a lot more opportunities. But the other thing that everyone should know, and I think everyone would agree, is that the opportunities aren't necessarily just going to be handed to you on a silver platter, and you still have to go out and take them. I knew when I started doing PI work that I wanted to try cases, so I quit my big law job 6 months in, which was a huge risk. Went to this PI firm that I kind of knew stuff about. They said they would let me try cases. Who knew if they were going to tell the truth or not? But when it came time for trial, I actually took one and I went, and I had spent so much time studying and preparing and learning trial skills and learning about personal injury that when the time came for me to actually show up, I kind of knew what I was doing, and I didn't embarrass myself, and I did a good enough job to earn their trust to try another case. And so you have to figure out what you actually want. If you want to be a plaintiff's lawyer, great. Figure out what you want within that. Do you want to be class actions? Do you want to be employment? Do you want to do single plaintiff PI? Do you want to write? Do you want to do trials? Do you want whatever it is? Figure it out. And then you have to go somewhere that's going to give you those opportunities. And then when you get the opportunity, you have to grab it by the horns, take advantage of it, and do your very, very best so that they can trust you. Because in this line of work, you need people who you can trust to run their own caseload. Fred is running the Camp Lejeune cases because his firm trusts him, because he's shown them that he's capable of doing it. So, and in other firms, it's not as important because they just need you to bill your hours because that's how they're going to get paid. But in this line of work, it's important that you show up, you show out, and you earn the trust of the people above you so that you get more and more opportunities, and you can grow a lot faster on this side of the ball than you can on the other side of the ball. You can become a partner, you can make a lot of money, whatever your goals are, you could get experience, whatever your goals are, can happen a lot faster on this side of the ball than on the other side. And for those of you who want to go to big law because of money, you will make more money as a plaintiff's lawyer, guaranteed. It just takes a little bit longer for that to happen.
Thank you. I think that's a perfect segue into our Q&A portion. So if people want to either use the raise hand function and do it that way, or if microphones aren't working and you want to put it in the chat, I can read out your questions, but happy to open it up now to anything you might want to ask. And don't be shy because they're here to answer all your questions.
I have a question. First of
Sure.
all, thank you guys for taking the time tonight. It was so interesting hearing from you and learning a lot. And kind of building off that, I really enjoyed hearing about some of these emerging areas that you find to be particularly intriguing. And I was wondering, as a law student, what areas, if you had extra time in your day to research, do you think that you would think it would be worthwhile to look into?
Molly?
That's a tough one. It's a little bit broad. Yeah, I guess I would like, as a plaintiff's attorney, not specific to like a certain practice area, like employment or consumer or something like that, then just like staying on top of it, you know, what's happening in procedure decisions, like I think would be what I would suggest.
I think it's ever changing. And I think it's like
Yeah.
like this week, it's the fires in Hawaii. Like what happened? You know what I mean? Who's going to investigate it? Who's going to handle those cases? We have someone in our firm that's licensed in Hawaii. Are we going to take those cases? Do we want to do it? Because we did a lot of the fires in California. But you know, it's I think a lot of people kind of try to predict like what the next, you know, medical device implant is going to be, or, you know, the next big thing that's going to happen. And to be honest with you, I think it doesn't matter if you're first. I think it has to happen. And then the best lawyers will come on and kind of take control of it. And that's how these types of cases get resolved.
Yeah, and I'll say I think a lot of plaintiffs firms as well have, you know, specific teams devoted to looking at areas of the law, you know, because we don't have client. I mean, John might have repeat clients, but by and large in class actions, we don't have repeat clients. We don't have financial institutions coming back. We don't have employers coming back to us. So constantly having to, you know, develop your reputation and develop the type of cases that you're bringing is something that is, I think, also unique to plaintiffs' work, and is, you know, if I could read SEC filings on what Ponzi scheme is developing out there all day, I would, but I have one that I have to focus on right now.
Right, and we have a question in the chat from Victoria Holmberg. She's asking, what's something a law student can do to prepare for plaintiff side work? And I think maybe if Molly or Emily could start off with this one, because I know you guys have interesting perspectives. One being, you know, Molly, you were a paralegal, and then also having clerked. Emily, yeah. So getting that perspective of paralegal versus clerking, I think would be interesting, and then opening it up to whoever.
Yeah, I can take that one first. I think clerking is a great experience. I think I will sing it from the rooftops. It's you get such a unique perspective of cases at so many different life cycles. There, at least in the trial court. I was at the district court. I know, Molly, I think you said you were at the state Supreme Court. At least at the district court level, if you want to be a litigator, it's such an interesting way to see just so many different types of cases. And I'm sure it's the same at the Supreme Court as well, you know, arguing one day, you know, a motion to compel, another motion to dismiss, summary judgment, trials. So I had trials on Zoom during the pandemic, and that's a different topic for a different day. That was a trip. But I'll say, you know, I think plaintiff-sided work, I think just building connections, and I think that's why a lot of you are here. I don't think in the past, at least when I was in law school, which was recently, plaintiffs' firms did a great job of advertising themselves and letting law students know that they were there. And I think the same can be said arguably for the schools as well, is that they didn't really tell students that they were there. So I think by being here and starting to build those connections, I can speak for my firm, like we want to hear from you. We want students, we really want to help build up this community. So this is a really great first step. And I think, you're going to learn the skills in your summer associate positions and especially within your first year. And if you clerk as well. Yeah, I think this is a great first step.
Yeah, and I mean, I was a paralegal before law school, so that was it was just sort of an exposure to what working in a firm sort of looked like and what litigation looked like. But then I agree with what Emily said about clerking and networking. I was on the Supreme Court, so I wasn't getting exposure to what it looked like at the trial court level. But what I thought was helpful about clerking was it was sort of like a bonus year to develop my legal analysis skills and the ability to talk about legal issues. Like I think in law school, you develop research and writing skills, but unless you do, and another thing I recommend is just work experience in law school, like through clinics or externships. But so much of what I do, I don't write a formal memo. I just look into things and then discuss it with my colleagues. So just to prepare for being a new associate, I think experiences where clerking or work experiences where you have to learn how to get on top of new issues quickly and feel comfortable discussing them is really helpful to start out as a plaintiff side attorney.
I totally agree with Molly. I think every single student should clerk at a law firm at some point during their 2L or 3L year. If you want to be a plaintiff's lawyer, at least in single plaintiff PI, your grades don't matter as much as you think they do. Grades are really important for bigger law firms, maybe your 1L year, but by the time it's your 2L or 3L year, the experience that you get from clerking at a law firm is going to be really, really valuable. Because if you've done discovery, if you've done demand letters before you start at a firm as an attorney, you're going to be ahead of the game. You're going to already hit the ground running, and it's going to be really useful for you. The other thing I would say is go watch a trial. Go see what actually happens in the courtroom. Go watch a trial, go watch a hearing, find out who is the boss in your town. Every city has a plaintiff side attorney who runs shit and is just the best. Find out when they're doing a hearing, find out when they're in trial, and it's a public courtroom. Just go in and sit and watch opening statements. I still do that now, and I've been a practicing lawyer for 5 years. If I know a good lawyer is giving an opening and closing, I'm going to go sit and watch, and I'm going to pick something up. I'm going to learn something. I'm going to steal something, and you'll get a feel just being there what it's like to actually be a lawyer, what it's like to actually be in trial, how they interact with the judge, how they look at the jury, all of these things. You're never, ever going to learn these things in law school. It's impossible. You just have to get out there and go do it. And if you're bored one day, you have something to do, you have time to kill, go to the courthouse, walk around, step into some courtrooms, just see what's happening. Some of them are going to be locked, some of them are going to be empty, but maybe you'll walk in on an interesting hearing and just see what's up.
Eric, I think you've had your hand up.
Yeah, hey guys, thank you so much for doing this. It's pretty amazing how invisible your perspective is, at least at my very silly law school. So my question goes back to something John was saying earlier about the revenue stream and the revenue model that plaintiffs firms use. And my understanding is that it goes pretty much entirely on contingency fees, which to me means that you guys must have to bake the probability of victory into your decision to take a case. So my question is if that means you ever have to turn down cases that you otherwise might like to take for a social justice reason or something like that, and how you go about making those decisions, and perhaps if there's a way that you can find some some capital for cases that aren't necessarily like a high probability of victory, but that you think are important for one reason or another?
Yeah, I think that the answer to this, I think this is a good point to maybe talk about how we talk a lot about plaintiffs law firms, but it's important to know that there really is a spectrum, I think. And probably on one side of that spectrum, there are firms that are essentially public interest firms or nonprofits that just happen to have a for-profit business model. And then on the other end of that spectrum, there are firms that are just profit-seeking businesses, and it so happens that their business is representing people who have been harmed. And then there are firms that sort of fall at different points in that spectrum, and that affects everything. That affects the cases they do, that affects their culture internally, how they conceive of themselves. It affects what they're, it affects really everything. And so I think as you guys explore firms you might want to work at, a really good sort of first question, and not necessarily to ask, or you could ask, but also just to think about, is to try to orient them on that spectrum from a public interest organization that happens to make money to the other end, a profit-seeking business that happens to do something good for the world. To the very specific question, I mean, KP is frankly fully on the business end of that spectrum. And that affects our answer to that question, where we don't really have people coming to us and asking for our representation. Instead, we look at different things that are happening in the world and treat them as investment opportunities. So sorry, that was my cat. So we learn about, a drug that has been found to cause cancer because of some new science that came out, and we will evaluate that as an investment opportunity. And if it makes sense, we will raise capital. There's a thriving ecosystem of litigation funders, and we will devote it to marketing and get plaintiffs and do the case. And if we don't think it's a good investment opportunity, however much we may agree with or find it to be a valiant mission to hold the wrongdoer accountable, it's just not really what we do as much. But I think others should opine, because different firms, and I think we have a good representation of them, see that question very differently.
To answer the question directly, I say no to cases more than I say yes to cases. And I think most personal injury firms are like that. And it sucks to say no sometimes, because it sucks to say no when there is a real serious injury or a death and there's no liable party. That's the hardest time. When there is obviously a liable party, but the injury isn't catastrophic or not big enough for my firm, I don't feel as bad, because another firm is going to take it. That's their business model. They'll be fine. Great. But when it's catastrophic, when someone's paralyzed or amputated and the person who hit them has a $100,000 insurance policy, no one is going to benefit from filing a lawsuit against that person and trying to collect against their personal assets, because that person with or let's say a $15,000 insurance policy doesn't have any assets. So we're just going to waste money filing a lawsuit, taking depositions, and put less and less money in our client's pocket. That being said, our firm is creative, and I think creativity was talked about a little bit earlier in this lecture series, or whatever we're calling it. And we find government liability in places that a lot of other firms don't find it. We find course and scope, people working for their business. We fight a lot of cases where we say this person was in their course and scope, and they say he wasn't, he was going home. And we'll fight on that, and we'll take that to a motion for summary judgment. And if we think we'll win, great. If we don't, then we'll settle before the hearing. And that happens a lot of times too, where we'll take a case, we'll do some discovery, we'll find some facts, and try to get a maximum result, whatever that is. We had a case where a tree branch fell on a kid and he had to have 3 brain surgeries. The city is immune under natural condition immunity. It was a tree in a forest, basically. We hired an expert. We spent a lot of money. We tried to come up with a really creative argument that the tree was improved and the immunity does not apply. And we got enough by the skin of our teeth to scare them into paying a decent amount of money before the MSJ was heard. And is he going to get the full result that he would have gotten? No, but he has something. He doesn't have to owe them costs if we would have lost the motion for summary judgment. So it's hard to say no. It takes practice. You get good at it the more you do it. I remember at the beginning of my career when I had to say no or turn down cases, it was a harder conversation for me to have. But no one benefits from filing a lawsuit that's a loser, to be honest with you. The attorneys don't benefit, the client doesn't benefit, system doesn't benefit either.
Thank you. I see Kiana had her hand up next.
Hello, everyone. Thank you so much to all of the panelists. My main question is on the side of bluntness, but just in merely curiosity. Whenever I communicate with probably someone in our career department, I voice things that they say are very earnest and don't promote being in the private sector. And continuing that thing is the idea of I'm not sure how you came to be in the position of these law firms and what you practice, but I don't know if I want to do class actions or how I want to help people. But I don't know the language in which how to communicate that to maybe employers or career advisors about how I want to go to a plaintiff side law firm, but I don't have the language to convey that well. Can you give me some advice of how to communicate that better to people, or maybe somewhere to look to get that language?
That's a really great question. I think as a first generation attorney as well, I didn't really know, and I really had to rely on advisors to sort of teach me that. So I think what you can talk to your, career development office about is being interested in plaintiff-sided litigation, that you're open to for, maybe firms of different sizes and different practice areas. And you don't know if you want to do class actions or what we call sometimes complex litigation, which encompasses sort of mass arbitration that Fred was talking about, or class actions that Molly and I were talking about. So there's sort of those kind of firms doing complex lit, and then there's sort of the more personal injury side. I can maybe let John talk about how he would describe his firm. I won't put words in his mouth. And then there's more, direct services, which I think encompass, in my mind, more of the sort of nonprofit world. But I think starting with plaintiff-sided litigation is a good place to start.
I think a lot of that research can be done on the internet and on coffee dates, to be honest with you. Again, I don't know what city you're in, but find different plaintiffs firms in your city, and guaranteed someone from your law school is working at one of those firms. Reach out to that person, ask them to get coffee, ask them what they do, ask them what their life is like. Do that with all the different types of plaintiffs firms you can imagine. And when you're a student, everyone is down to get coffee with you and take you to lunch or whatever. When you're not a student, no one cares about you anymore. So you got to do it while you're a student, because once you become an attorney, then they're not as willing to make time, but they will make time for you. So you got to take advantage of it now and really explore what you want. I was doing a coffee date here and there every week or so during my first year of law school, just to see what was up and just to figure out what I liked, what people's lives are like, what I wanted to do. So that's probably the best way to learn what that's like. And you make a connection, and then maybe one day you want to apply to that firm and you reach out to that person and they're the one who gets you connected and it works out.
And then we have Julia, NPLA Creative Director.
Thanks for blowing up my spot, Yusuf. Thanks everyone for being here. Really appreciate all the different perspectives and just learning so much. I had a question, but I think Haley's in the chat is better, so I'm gonna just read hers instead. And then if you guys want to hear what my question was going to be, I could just tell you. But she wrote, most OCI offers will expire before a lot of plaintiff side firms even begin interviewing for summer associates. Do you have any tips on how to navigate your early career for someone who is very interested in plaintiff side work, but nervous about voluntarily striking out at OCI?
I can take this one. I mean, I think, just to be clear, this is one of the hardest and most annoying things about being a law student who wants to do plaintiff's law. And it's something that at least when we were doing HPLA, the Plaintiffs Law Association at Harvard, we really pushed people on. And the answer, I'll just be totally candid with you guys, for a lot of these firms was they tried to dress it up differently, but it was basically we're just kind of not on top of it enough to hire that early on. So I definitely understand the frustration, and I agree it sucks. I think the way to solve it kind of there are different ways to go about it. So one is a lot of these firms, the flip side of them not participating in OCI is that if you harass them enough, they actually might interview you and hire you earlier. And it's always worth giving that a shot and really sort of communicating interest and being very direct about the quandary that you're in and asking them to help you solve it. It is also not, off limits to ask to split a summer, right? And some plaintiffs firms will, some big law firms at OCI will allow you to accept the offer, and you can say upfront as you accept it, heads up, I'm applying for some of these other less conventional opportunities and want to confirm that you'd be open to me splitting if I end up getting one. And then there's the third option to just sort of skip OCI and use it as an interview chip and say in your plaintiff law interviews later, look, like I forewent opportunities to be able to participate in this, and your risk tolerance may vary, but those are at least some options. And I think the long-term solution to this, though, is Laura and co. convincing all of the plaintiffs' law firms to just fix this because it's dumb and there's no reason that they need to be off cycle with everybody else.
I think the reality is I think the root of that hesitation or that fear comes from, what if I don't accept this defense OCI job and then I don't land a job at a plaintiff's firm? And the reality is, and I'm here to tell you, is that you will get a job. Everyone gets a job. Everyone who finishes law school gets a job. That's how it goes. It may not be your dream job to start, but you will get a job. You will get a job at a summer plaintiffs firms. Plaintiffs firms can always use more help, can always use a competent, qualified summer attorney. If you are someone who is going to land an OCI job, you are going to get a job at a really good plaintiffs firm. I would not be worried about it.
I will also say I serve on the law clerk hiring committee for my firm, and at least for the specifically plaintiff side employment law, like it's a pretty niche interest, and so like a very demonstrated interest to working specifically for our firm in employment law. Like if you can show that, like I think that you don't have to worry about foregoing OCI opportunities if you're committed to doing plaintiff side work in the subject area that you're interested in. And I also have lots of students reach out to me all the time that from Berkeley's Career Center, who the Career Center has provided my email address, and they reach out and ask for informational interviews. So you can do that in advance of OCI hiring and learn about firms and make connections.
And if you're wobbling, you don't have to be a plaintiff's lawyer the first day you pass the bar. Like, I went into big law. I wanted the security. I took a 2L summer job, made a bunch of money. I took my first year associate job. They were paying it was amazing. And then I quit and they couldn't do anything about it. And it was totally fine. So if you're unsure, it's okay to OCI an interview, and you're going to have a long career when you're a lawyer. It could be 50, 60 years that you're going to be practicing. It's silly to think that you're going to be doing the same thing that entire time. And you can get out of whatever you're doing whenever you want. I'm a big proponent of people quitting their jobs, by the way. But we can talk about that another time.
That's all true. I think it also, though, again, always makes sense to recognize that plaintiff's law is not a monolith, and there are lots of different firms that feel very different ways about different things. And so I think it's certainly true that, for example, KP, we love ex-defense people. I mean, the firm was started by people who were, as big law as you can get. I mean, the Postman of Keller Postman was the director of lit for the Chamber of Commerce, of all things. But then there are other firms, right, that are within this group of plaintiffs law firms that are way more mission focused, and I think for totally justifiable, are totally justifiable in their resistance to hiring people they don't think are really committed to the mission, right? I mean, some firms don't want tourists, and I think that's totally fine also. And so you should I do think it's worth being, being realistic with yourself. Nothing's impossible. People execute huge career turnarounds, but there are certain segments of the law that are more mission oriented where, yes, if you wanted to go be a public defender or go work, as a as a housing lawyer, you probably would not want to work for a big law firm that does, that defends landlords, and the people at the tenant side housing firm would probably not be so sympathetic to you saying, well, I really wanted the money. And so it's just, this varies a bit. In general, life is long and you can change stuff, but it's just worth thinking about what specific segment of plaintiff's law you want to work in.
And Taryn, I see you have your hand up as well.
Yes, hi. Thank you thank you so much for this talk. And I guess I want to maybe ask this question to each panelist individually, because it's would probably depend on the type of the plaintiff's firm. But I guess I was wondering, for somebody who's a rising 2L, what courses would be to you, as whether, some of you mentioned on the hiring committees at your firms, what courses would you look at to see, that would be of interest to you for your firm? For instance, I mean, some would probably apply to plaintiffs' firms generally, like complex litigation, but what coursework would you be interested in a potential attorney at your firm having?
I can take that one first. For me, at a complex litigation firm, any sort of advanced civil procedure. I don't know what everybody's Civ Pro course looks like at their various law firms. I didn't learn about Rule 23 until my advanced civil procedure class, which is the rule that talks about class actions. So I would recommend that. But otherwise, take your prep courses, take your bar prep courses, take things that are, interesting to you. I think that makes somebody more interesting. And also I would push more towards experiences like clinics, and externships. I think those are to get real world experience is unparalleled. I did a clinic in my 3L year, and I vastly enjoyed it, and really got an interesting experience in the voting rights sector and prison reform, which my firm has a task force on. So I think that's more important than your actual coursework.
Do you mind? I have to hop off in 1 minute, but just to give you a sense of the range, KP is a bit of a different, I think would just take it a bit of a different approach. I mean, what we generally look for on transcripts are just sort of meaty, success in sort of meaty black letter law courses. Just because our practice involves so much of that, right? Like the stuff we do, there's a huge Civ Pro and federal courts component of it, and we love that stuff. But we also substantively, we do employment law, we do antitrust, we do we do torts, which involves sort of state tort law, I guess, but has a lot of interaction with preemption and regulatory issues. So those statutory classes like financial regulation, securities regulation, you may or may not have an FDA type med devices and drug products type class, and we like a lot of that stuff, and generally just look for people that are kind of legal athletes, but also have a bit of an entrepreneurial streak that lets them do the more plaintiffy stuff. I do have to drop. Thank you guys. Really nice to meet everyone.
Thank you.
Thanks, Laura.
We're actually out of time at 6:15, so thank you guys so much for coming. And this was really amazing to hear all of your experiences. And we have our NPLA job fair on the 30th, and firms will have their own rooms, and people can hop in and find out more about their practice areas. But thank you guys so much for being here.
Thanks, everyone.
Thanks. This was great.
Yeah, thank you so much.
Hi, everyone. Thank you. My email is on my name here. If you have any questions or want to discuss, shoot me an email.
And you can also share mine, Plaintiffs Law Association, out to the attendees. Thank you.
Thank you.
Thanks.
Thank you guys so much.